John L. Lewis, Plaintiff Appellant, vs. United States of America, Defendant Appellee, 680 F.2d 1239 9th CIR. 1982. U.S. Court of Appeals for the Ninth Circuit 680 F.2d 1239 9th CIR. 1982. Submitted March 2, 1982. Decided April 19, 1982. As amended June 24, 1982. Lafayette L. Blair, Compton, Cal. For Plaintiff Appellant. James R. Sullivan, Ast. U.S. Atty. Los Angeles, Cal. Argued, for Defendant Appellee, Andrea Sheridan Orden, U.S. Atty. Los Angeles, Cal. On brief. Appeal from the United States District Court for the Central District of California. Before Poole and Boochever, Circuit Judges, and Solomon, District Judge. Poole, Circuit Judge. On July 27, 1979, appellant John Lewis was injured by a vehicle owned and operated by the Los Angeles branch of the Federal Reserve Bank of San Francisco. Lewis brought this action in district court alleging jurisdiction under the Federal Tort Claims Act, the Act 28 U.S.C. Section 1346b. The United States moved to dismiss for lack of subject matter jurisdiction. The district court dismissed, holding that the Federal Reserve Bank is not a federal agency within the meaning of the Act and that the court therefore lacked subject matter jurisdiction. We affirm, in enacting the Federal Tort Claims Act, Congress provided a limited waiver of the sovereign immunity of the United States for certain torts of federal employees. United States v. Orleans, 425 U.S. 807, 813, 96 S. Court 1971, 1975, 48 L. F.2d 390 1976. Specifically, the Act creates liability for injuries, caused by the negligent or wrongful act or omission, of an employee of any federal agency acting within the scope of his office or employment. 28 U.S.C. Sections 1346b 2671. Federal agency is defined as the executive departments, the military departments, independent establishments of the United States, and corporations acting primarily as instrumentalities of the United States, but does not include any contractors with the United States. 28 U.S.C. Section 2671. The liability of the United States for the negligence of a Federal Reserve Bank employee depends, therefore, on whether the bank is a federal agency under Section 2671. There are no sharp criteria for determining whether an entity is a federal agency within the meaning of the Act, but the critical factor is the existence of federal government control over the detailed physical performance and day-to-day operation of that entity. United States v. Orleans, 425 U.S. 807, 814, 96 S. Court 1971, 1975, 48 L. F.2d 390 1976 Logue v. United States, 412 U.S. 521, 528, 93 S. Court 2215, 2219, 37 L. Ed. 2d 121 1973. Other factors courts have considered include whether the entity is an independent corporation, Pearl v. United States, 230 F.2d 243 10th CIR. 1956 Freeling v. Federal Deposit Insurance Corporation, 221 F. Sup. 955 W.D. Okla. 1962 Aft per curiam, 326 F.2d 971 10th CIR 1963 Whether the government is involved in the entity's finances. Goddard v. District of Columbia Redevelopment Land Agency, 287 F.2d 343, 345 D.C. CIR 1961, cert. Denied, 366 U.S. 910, 81 S. Court 1085, 6L. Ed. 2d 235 1961, Freeling vs. Federal Deposit Insurance Corporation, 221 F. Sup. 955, and whether the mission of the entity furthers the policy of the United States, Goddard vs. District of Columbia Redevelopment Land Agency, 287 F.2d at 345. Examining the organization and function of the Federal Reserve Banks, and applying the relevant factors, we conclude that the reserve banks are not federal instrumentalities for purposes of the FTCA, but are independent, privately owned and locally controlled corporations. Each Federal Reserve Bank is a separate corporation owned by commercial banks in its region. The stockholding commercial banks elect 2/3 of each bank's 9-member board of directors. The remaining 3 directors are appointed by the Federal Reserve Board. The Federal Reserve Board regulates the reserve banks, but direct supervision and control of each bank is exercised by its board of directors. 12 U.S.C. Section 301. The directors enact bylaws regulating the manner of conducting general bank business, 12 U.S.C. Section 341, and appoint officers to implement and supervise daily bank activities. These activities include collecting and clearing checks, making advances to private and commercial entities, holding reserves for member banks, discounting the notes of member banks, and buying and selling securities on the open market. See 12 U.S.C. Sections 341 to 361. Each bank is statutorily empowered to conduct these activities without day-to-day direction from the federal government. Thus, for example, the interest rates on advances to member banks, individuals, partnerships, and corporations are set by each reserve bank, and their decisions regarding the purchase and sale of securities are likewise independently made. It is evident from the legislative history of the Federal Reserve Act that Congress did not intend to give the federal government direction over the daily operation of the reserve banks. It is proposed that the government shall retain sufficient power over the reserve banks to enable it to exercise a direct authority when necessary to do so, but that it shall in no way attempt to carry on through its own mechanism the routine operations and banking which require detailed knowledge of local and individual credit and which determine the funds of the community in any given instance. In other words, the Reserve Bank Plan retains to the government power over the exercise of the broader banking functions, while it leaves to individuals and privately owned institutions the actual direction of routine. H.R. Report No. 69, 63 Kong, 1st Sess. 18-19, 1913. The fact that the Federal Reserve Board regulates the reserve banks does not make them federal agencies under the Act. In United States v. Orleans, 425 U.S. 807, 96 S. Court 1971, 48 L. Ed. 2d 390 1976. The Supreme Court held that a community action agency was not a federal agency or instrumentality for purposes of the Act, even though the agency was organized under federal regulations and heavily funded by the federal government. Because the agency's day-to-day operation was not supervised by the federal government, but by local officials, the court refused to extend federal tort liability for the negligence of the agency's employees. Similarly, the Federal Reserve Banks, though heavily regulated, are locally controlled by their member banks. Unlike typical federal agencies, each bank is empowered to hire and fire employees at will. Bank employees do not participate in the civil service retirement system. They are covered by workers' compensation insurance, purchased by the bank, rather than the Federal Employees' Compensation Act. Employees traveling on bank business are not subject to federal travel regulations and do not receive government employee discounts on lodging and services. The banks are listed neither as wholly owned government corporations under 31 U.S.C. Section 846 nor as mixed ownership corporations under 31 U.S.C. Section 856, a factor considered in Pearl v. United States, 230 F.2d 243 10th CIR 1956, which held that the Civil Air Patrol is not a federal agency under the Act. Closely resembling the status of the Federal Reserve Bank, the Civil Air Patrol is a nonprofit, federally chartered corporation organized to serve the public welfare. But because Congress's control over the Civil Air Patrol is limited and the corporation is not designated as a wholly owned or mixed ownership government corporation under 31 U.S.C. Sections 846 and 856, the court concluded that the corporation is a non-governmental, independent entity, not covered under the Act. Additionally, reserve banks, as privately owned entities, receive no appropriated funds from Congress. C.F. Goddard v. District of Columbia Redevelopment Land Agency, 287 F.2d 343, 345 D.C. CIR 1961, Cert. Denied, 366 U.S. 910, 81 S. Court 1085, 6L. F.2d 235 1961 Court held Land Redevelopment Agency was federal agency for purposes of the Act in large part because agency received direct appropriated funds from Congress. Finally, the banks are empowered to sue and be sued in their own name. 12 U.S.C. Section 341. They carry their own liability insurance and typically process and handle their own claims. In the past, the banks have defended against tort claims directly, through private counsel, not government attorneys, e.g., Banco de España v. Federal Reserve Bank of New York, 114 F.2d 438 2 DCIR.